welcome everyone. Thank you for being here today for this really important conversation. So this is part of our Dean's Distinguished Speaker Series in recognition of our centennial year, where we're bringing together really important voices in our community. So to have just a really rich set of conversations. So today's panel discussion highlights an incredibly important topic: diversity in the judiciary. As many of you know, at Loyola Law School, we have more judges and justices on the state court than any other law school in California. It's something we're quite proud of. So it's really a very appropriate time and space to have this conversation. Let me briefly introduce our panelists today. First, we have Judge Arakaki, class of 1998. Judge Arakaki was appointed to the California Superior Court, LA County Bench, in 2010 by Governor Schwarzenegger after more than 10 years as a public defender. She's continued to grow in this transition from litigator to judge. Prior to her judicial appointment, she was a deputy public defender for the LA County Public Defender's Office. Before that, she worked for the law offices of Steve Escobar. Outside of the courtroom, she has a full and important plate of civic involvement, including serving as president of the Japanese American Bar Association. And currently, Judge Arakaki is sitting in the Edmund D. Edelman Children's Courthouse in Monterey Park. So Judge Arakaki, thank you for joining us today. We're also joined by Associate Justice Carol Codrington. Carol is a 1984 graduate who attended the Evening Division. Justice Codrington was nominated in 2010, unanimously confirmed by the Commission on Judicial Appointments. Justice Codrington was the first African-American justice on the 4th District Court of Appeal, District 2 in Riverside, and the first African-American female justice in the state of California. She was appointed to the Riverside Superior Court in 2007. Before that, she was in private practice, including time as an associate at Burke, Robinson, and Perman, and also spent time at the Western Law Center for Disability Rights, now known as the Disability Rights Legal Center, and even an adjunct professor at Loyola Law School. So welcome, Justice Codrington. We're also joined by Judge Serena Murillo, class of 1996. Judge Murillo has been on the LA Superior Court since 2014. She was appointed by the Chief Justice of the California Supreme Court to serve on the Pretrial Detention Reform Work Group in 2016 and co-authored the report Pretrial Detention Reform Recommendations to the Chief Justice. She's a member of the California Latino Judges Association and the California Judges Association. She's also a former member of the State Bar's Commission on Judicial Nominees Evaluation, and since 2007 has contributed as a panelist for numerous bar associations on issues pertaining to diversity on the bench. Last, but certainly not least, we're joined by Judge John Meigs, class of 78, also the Evening Division. Judge Meigs serves as a trustee of Loyola Marymount University and also as a board member of our Loyola Law School Board of Directors. He serves on the Leadership Council of the Loyola Black Alumni Chapter and is also a former member of the Alumni Association Board of Governors. Judge Meigs was elected a commissioner of the then Inglewood Municipal Court, now the Superior Court of California, in January 1989, and then on October 27, 1993, he was appointed a judge by Governor Pete Wilson. He served as presiding judge from January 1994 through December 1996. Judge Meigs, a separate conversation we can have is how glad you are not to be presiding judge at this particular moment. Before his service to the bench, he was a founding partner of McKinney, Peters, Granville, and Meigs, where he worked as his appointment as a commissioner. He also served on the board of the John Langston Bar Association for 10 years, including service as the group's president in 1998. Last note on Judge Meigs, he attended law school after his service to our nation on the GI Bill. He's a Vietnam veteran who served in the United States Army from February 1968 to December 1971, attaining the rank of captain. He received, amongst other honors, the Vietnamese Police Honor Medal, the Army Commendation Medal, in the Bronze Star. So Judge Meigs, thank you. And thank you, all of you, for being here today. So let me kick things off. Judge Arakaki, I'll start with you, and then we'll just go around. Can you talk to us about how you found your path into public service, and in particular on the bench? There are so many things for junior lawyers to enter the profession and do. I guess I'll ask all of you, but I'll start with Judge Arakaki. How did you find your path to being on the bench?
Well, first off, let me just say, Michael, thank you very much for allowing us to participate in this. My mom would look at this panel and ask me what the heck I'm doing here with this illustrious group of jurists. And I'm going to first off say thank you, and thank you to them for their service. When we talk about being on the bench and we talk about public service, I think it's something that we often forget. Being a judge is a great career, but it really is about being of service. And that's how I ended up here. I had no intention of becoming a bench officer when I was younger. I actually went to law school with the intent of becoming a public defender to represent children. That was what my goal in life was from the time I was about 15 years old, because I had a bunch of friends who were getting in trouble, ended up in the juvenile delinquency system, and really could have used or could use, even today, I guess for all kids, a good advocate. There's so many avenues in which somebody can do that now, but at the time, I got kind of stuck on an idea, and it actually was a good one. And I decided to become a public defender, and that was my goal. It was either be an educator, a social worker, or a lawyer, I figured, because I did want to be of service and to help people. Coming from a family of all educators, all of the women in my family were educators in some form or fashion. And so I figured my vehicle of being of service and to try to help children would be to represent them in the legal realm. And so that's how I ended up as a public defender, and having the ability to serve in that office for the majority of my career, representing kids in the juvenile delinquency system. I just loved it. It just so happened, though, somebody suggested that I put my papers in. I had no intentions, like I said, of really doing it, but on a whim, I put my application in, and you just never know what could happen. And here I am. And I'm now sitting in the juvenile dependency court. I'm sitting as the supervising judge of the juvenile dependency court here in LA County. And it kind of has come full circle for me in that I get to work with not only kids in the juvenile justice system, but on the dependency side, serving their families in hopes of helping them to stay out of a juvenile justice system. And so kind of that's how my path has run so far.
Thank you, Judge Arakaki. Justice Codrington, same question.
Yes. My path to the bench, not counting my time as a city attorney and working for LA Unified School District as an associate general counsel, my time on the bench was similar to Judge Arakaki's, in that on a whim on a Friday afternoon at 3:30 p.m., I filled in an application to be a commissioner and delivered it at 4:55. And I was really surprised when they called me for an interview. And they told me that there would be second interviews, and then they called me the next day and say, never mind, they're not going to be second interviews. We want you. And that's how I started my path to the bench. And about 9 months later, I was urged to put in my papers by my colleagues, and did so, and got appointed to the Riverside Superior Court. And then 2.5 to 3 years later, I was encouraged again to put my papers in for the Court of Appeal. And again, to my shock and amazement, I was appointed by Governor Schwarzenegger to the Court of Appeal, 4th District, Division 2. And at that time, I was and still am the first African-American female justice in our court and in our division.
Thank you very much for that. Judge Murillo?
Thank you. And Dean Waterstone, I echo Judge Arakaki's and Justice Codrington's comments. Thank you for having me as well. Much like Judge Arakaki, although she wouldn't characterize her journey this way, but I certainly would characterize mine this way. I think I kind of stumbled into public service. One thing that wasn't mentioned was my background. My father had just moved here from Mexico a few years before I was born, and he was a migrant farm worker, as were my grandparents and all the aunts and uncles and everybody that I lived with. And so I had this vague notion out of college that I wanted to be a civil rights attorney without having any real understanding of what that meant. I didn't know any lawyers. I was the first one to go to a 4-year university in my family. I certainly didn't know any judges. I didn't really know anything about the legal system whatsoever. But there were 2 incidents that made me want to go to law school. First, just my own family's experience as farm workers and many of the injustices that I felt had occurred that I thought that I could kind of make a right out of a wrong. And secondarily was the fact that when I was growing up in Chino, which is a farming community, or at least it used to be, not too far from Los Angeles, there were a large number of Japanese farm owners who were my friends. And I was dismayed to find out, not until college, that the Japanese internment had even occurred. And I had a professor named Peter Irons who had written a book called Justice at War. And it was really eye-opening for me and troubling to know that this had happened in the midst of the place where I grew up, and I had never learned a thing about it. And so those 2 factors really combined and made me want to go to law school. And thankfully, Loyola gave me that opportunity. But once I got to Loyola, I feel like I just kind of stumbled upon trying to find meaning in what I wanted to do. And thankfully, I was assisted a great deal by 2 primary people. The first was Bill Hobbs. He ran the Center for Conflict Resolution at the time. I was on loans and working through law school. And he really took me under his wing and served as something of a mentor and helped me see that I could do so many other things in law, and it urged me to take his clinic on working at the district attorney's office, because by then I had formed this idea that, well, maybe I could be a public defender. I mean, it was really a period of kind of finding myself when I was at Loyola. I did not come in with this idea of what exactly I wanted to do. I wasn't in it to just make money. I was in it to feel like I was contributing something meaningful to the world. And so Professor Hobbs helped me a lot, because he led me to the district attorney's office to get trial experience. The other person was Professor Chris May. Constitutional law, when I took that with Chris May, was one of the best experiences in any class I have ever had. I mean, he really opened my eyes to the power of the Constitution, the power that people have, and what you could do about it as a lawyer. And I felt very lucky to have that educational experience with Professor May, because it still serves me, frankly, today. So those 2 things helped me once I got to the district attorney's office. I didn't know if I wanted to be a DA or a public defender. I actually really wanted to be a public defender, but I kind of learned to love the district attorney's office. And it was when I was there that I met a judge named Michael Pastor, who I looked up to and thought, he's the only person in this courtroom who has a better job than I do. How do I get that job? And that actually was the reason that I then joined the Jenny Commission, to learn how to even become a judge, because I had absolutely no idea. And then that led to me ultimately becoming a judge. So I feel like through a series of good opportunities and people kind of assisting me along the way, that I got to do what I really, really love, which is being a judge at this time and having a career in public service, which I think is important because it is meaningful. And I think it's something that not too many lawyers can say that they love their job after a few years. And I can say that I have always loved my job and the career choices that I've made over the last 20, 25 years.
Thank you so much for that. And thank you for the kind words about Bill Hobbs and Chris May. I never got to know Bill, but Chris and I overlapped for several years, and just a beautiful human being. And I feel like I learned so much from him about how to be a law professor. When you talk to people who were in his classes, you know, the best analogy I've heard is he was like, you know, a renowned orchestra conductor, just in terms of the way he would manage and teach his class. And when you speak to students who were in his class, they just remember how amazing he was. So Chris is still doing well, still talk to him from time to time. So thank you for commenting on that. Judge Meigs.
Yes, Michael.
How did you become a judge? What was your path to public service?
Actually, while I was going through training for military intelligence, we had, there were a number of lawyers that were in the class who had, you know, deferred their military service while they finished law school, and then because of their legal background, were given the opportunity to become military intelligence officers. But a lot of what we studied during that course had to do with search and seizure and those types of things. And that's when I first started thinking about the law. But somewhat like Serena, because of the community that I grew up in, and even more so because of an incident in my family, I'm one of 7 children. And after being commissioned and finishing my training in military intelligence, I was actually assigned to what at that time was the largest field office in the country, and it was in Pasadena, at what is now the Ninth Circuit Court of Appeals. And it was while I was there during the Watts Summer Festival, I had actually been detailed there to man a listening post in case there was some sort of activity that might result in a request for National Guard. So I was supposed to be the ears on the ground to help advise if that should happen. But things went well. It was a great weekend. I was 2 blocks from my parents' home, so I was able to go there and have lunch and that sort of thing. But during the final evening, my middle brother ended up getting arrested. And he was arrested for what I guess you can call contempt of cop. My youngest brother had been rear-ended on the freeway, was taken by ambulance to an emergency room, and his passenger was injured but had no health insurance, so she was taken to a clinic, and I had to go by my parents' house to get a copy of their policy before the clinic would treat her. And I asked my brother if he would go and wait for her to take her home while I went to the hospital where my brother had been taken, my youngest brother. And while he was there in the waiting room, police were bringing people in for treatment before they were booked. And one of them got into a staring contest with my brother, who stared back and ended up getting arrested. And the really strange thing about it was that the officers threatened to arrest the doctor who was in charge of the clinic when he went out to ask them what they were doing, because his nurses had told him that my brother was just sitting there. So it was then that I decided that someone in our family needed to know something about the law. And I told myself then that once I got out of the Army, I would do whatever I had to do to get into law school so that I would have that kind of knowledge. And as it turned out, my parents ended up hiring a lawyer, and they ended up going through what was called a civil compromise in that time. And I think these have been ruled unlawful, but by agreeing not to sue the city for false arrest, they dismissed all the charges against them. But this was after my parents had paid the lawyer and had posted bail and that sort of thing. And that really impacted me. And I had decided I was going to be a defense attorney. During, I guess, rolling admissions, I got accepted and ended up going to Loyola at night. And while there, because of some other Loyola graduates who I knew from my fraternity days, I was convinced that I should go to work in the district attorney's office because I could do more to help innocent people as a prosecutor. And this is what both Al Jenkins, who you may know, he's a retired deputy district attorney, but he was a classmate, and Rodney Forneray, who was my colleague on the bench in Inglewood for 15 years. And he graduated just as I was starting the law school. But they had both convinced me that I needed to go into the district attorney's office because I could then make sure that those cases that didn't have merit didn't go anywhere. Well, I think that was in another world. But at any rate, when I came out of law school, passed the bar, interviewed with the district attorney's office, and probably because of my military background, of course, the GI points, I was in band 1, which normally meant that you get hired right away. But it was after Prop 13, the district attorney had a hiring freeze. And I ended up meeting someone who was a district attorney, and he was a retired LAPD lieutenant, Marion Johnson. He's now a retired Superior Court judge. But when he was told that I was on the list for DA, he told me that they're not hiring, they're talking about laying off, but the public defender's hiring. And I said, look, I'm not gonna represent criminals. And he gave me, I had met him 5 minutes earlier. He gave me a 15-minute lecture on why it was important for both sides to have adequate, forceful representation. And based on that, I applied that next week in the public defender's office. My first 9 months in the office, I tried 23 jury trials to verdict. And at that time, I decided I was going to spend my entire career as a public defender. And I realized for me that it was a better fit than being a prosecutor. But as time went on, my older son was accepted to Stanford. I couldn't afford to pay his tuition based on my public defender salary, and that's when I went into private practice. And while in private practice, I was contacted by several judges in the Inglewood courthouse when they were interviewing for a new commissioner and encouraged to apply. And I applied, I was selected, and I realized that that was my calling. I think since I've been on the bench, I have really seen the effects that increased diversity have had, and I've been very active in doing everything I can to promote that.
Thank you, Judge Meigs. I really appreciate that answer. For those of you that don't know, the last time I was called to jury duty, it was in Judge Meigs' courtroom. So we can share that story later. There was a moment where I didn't know what to do. Judge Meigs asked as we were starting, please stand up if you know any of the participants in the courtroom today, or raise your hand and let us know. And all I could think of is, I know you, Judge, but I'm not sure the right answer to this question. So I kept my mouth shut. But so one quick question, and I can throw this out to anybody. Judge Meigs and Judge Murillo, you touched on this, but could any of you comment? One of the conversations we have at Loyola is about the role of mentors and the role that mentors can play in your life, the art of finding mentors, the art of being a mentor. Could any of you comment on mentors that you had that helped you make that transition to the bench, that gave you confidence that you could do that role, that pushed you, that helped you grow your networks? I'd love to throw that question out to anyone.
I'd love to take that one.
Yes,
Justice
please.
Candace Cooper was a longtime mentor of mine and still is a very dear friend, like a sister to me. I met her my first year of law school because I was attending Loyola with her sister, Crystal Cooper, and we would go to her house on Saturdays to study. And from that time on, she's always been instrumental in helping me with writing. And now she and I, along with Al Jenkins, team teach a bar review course and have done so at Loyola and many other campuses for the last 20 years. So she's a big mentor. And the other mentor, I would have to mention my parents. They're both immigrants from Belize in Central America. So I'm the first generation American, and they became United States citizens, and they were very, very proud of that and really wanted all of us to know about the Constitution and sort of force-fed the Constitution to us as children. And that kind of started me down the path. But this is going to sound really crazy. I really got interested in being a lawyer by watching Perry Mason with my aunt. That was the first lawyer I ever saw, the first lawyer I knew about, because there were no lawyers in my family, in my neighborhood, and no one had attended law school in my family. So and to this day, there was recent survey taken by the ABA, and it said to this day, he is the favorite lawyer of many lawyers. And I find that funny since that show is so old, but I have to admit, I watch it every single day to this day. And I always try to pick up something from what I see in terms of his arguments, as well as the judges that participated in that show. So for me, the greatest mentor is Justice Cooper, Justice Arlie Woods, who I also did an externship with as a law student, and John Meigs and other judges that really just encouraged me along the way. So I'm very, very proud to have all of them as mentors in my career.
Thank you, Justice. Anyone else on that question?
I guess I should let Justice Codrington know that they're doing a reboot, right, of Perry Mason. So apparently now they're redoing it, so she'll have new things to watch. I think that with regard to mentorship, I'm recognizing now, we can all talk about our mentors, and we've all had key people in our lives. I know that I had a number and I could go down the list, but I think I'm recognizing now the onus on us to be now mentors. I had never considered myself to be a role model, to be anyone worthy of mentorship, right? To mentor somebody. And I think in these times, I'm recognizing how grateful I am for the mentors I have had. But more importantly, the fact that they have passed on a torch to us to actively seek being a mentor to others. I think that in our role, I know I was kind of taking for granted the fact that, if somebody needs a mentor, they'll reach out or they'll ask. And I didn't recognize that unless we open ourselves up to it and let people know that we're willing to be mentors or actively seek out those opportunities to be mentors, I guess people in some regard are hesitant to make the ask. And so I'm trying to be better about being open with younger lawyers or older lawyers, for that matter, anyone, that I'm available for that in that capacity, in that role, whether it be for lawyers, high school students. I've taken on a couple of high school students actually now to really try to encourage them and be a mentor to them regarding just being open to any type of public service or whatever endeavor they want to take on. But I guess really recognizing that I am so grateful to all of the mentors I had while at Loyola, but just even through life, my parents, all of that. But recognizing really the need to actively go out and seek individuals to mentor to.
Thank you for that.
And I'd like to
make
a couple of comments along that line, Michael, if you don't mind.
Yes, please. Please.
One of the things I think has really been helpful to many of us, or most of us in communities of color, are the ethnic bar associations. You mentioned that I was president of the Langston Bar. It was actually 1988, while I was still a lawyer, that I was president of the Langston Bar Association. And I joined the Langston Bar Association right after passing the bar. And at that time, there was a president of the Bar Association, Alan Webster, who's now a Superior Court judge in Compton. But Alan had a way of mentoring without you realizing that he was mentoring. And one of the things that he felt was that we needed to be involved not only in minority bar activities, but also in the general bar. So he would call me up and tell me that there was an important meeting of some committee of the county bar or some section of the county bar, and he wasn't able to attend because he had another obligation. Would I attend in his place? And by doing that, I met a lot of people that were in other areas of practice. And as time goes on, you can network with them and help build those resources up. But when I went into the public defender's office, I was shocked that in an office at that time, they only had, I think, maybe 550 lawyers. And I was one of 9 African-American lawyers. And there weren't, there may have been 12 Mexican-American lawyers. And we realized that there was something wrong, and actually went to the public defender at that time, Wilbur Littlefield and told him that something needed to be done. And what he said to us, and there were a group of 5 of us that went, and what he said was that, well, what I've been told by my people is that we can't hire Black and Mexican American lawyers because all the civil firms are grabbing them. And we said, you give us an opportunity to reach out to the law schools, and we guarantee you that we'll be able to find people that will make good public defenders who want to be public defenders. But anyone who looks at this office now would feel that perhaps they're not wanted. And we got involved to the point where they had a 2-person team that did all the interviews. And we got him to agree to put 1 more person on the team. And we would have one of our African-American lawyers or one of the Mexican-American lawyers sitting on those teams. So if we had candidates that were coming up, we would let them know. If they had candidates, they would let us know. And many times we had to kind of neutralize those other 2 people who wouldn't know a good lawyer to be if they were in front of them, if they were Black or brown. So, you know, I'm happy to say now that both the Public Defender's Office and the alternate Public Defender's Office have greatly increased their representation of people of color, which I think makes a big difference in how those indigent clients are represented when they're before the system. And it's, you know, the people from those offices that have a lot to do with the candidates who later become judicial officers, because they're in court all the time. And I think that has led directly to making changes in the composition of the bench. And these same ethnic bar associations have groups of judges that work on mentoring new judges and also in developing lawyers into becoming candidates for judicial office. And we're, particularly with the last 3 governors, we've seen some really tremendous results in increasing the diversity on the bench by programs such as So You Want to Be a Judge and others like that. But you know, we work with the candidates on their applications. We have judges that will do mock interviews for them so that they're prepared for the Jenny Committee or the governor's appointment secretary. And this current governor, in appointing Marty Jenkins as his judicial appointment secretary, has really gone over and above. And he promises to really diversify the bench, not just ethnically, but in a lot of other ways. And I think we're going to see a bench in the future that's much more representative of the diversity of the state of California.
So thank you, Judge Meigs. If I could pick up on that, while it is wonderful and we should celebrate and acknowledge, you know, positive progress and the positive trajectory, one of the conversations we have a lot at Loyola is that the legitimacy of the profession depends on the legal profession representing the clients that we serve. Because at the end of the day, we're a service profession, you know, the legal profession generally. And we are not there yet as a profession. We are not there yet as a judiciary. From your vantage points, what challenges remain, and, you know, thoughts on tools, strategies to move ahead to having a more diverse, inclusive, representative legal profession and judiciary? And I guess I'll say, to the extent that there is a role for, you know, American legal education and law schools to play, you know, don't spare us in your comments either. And I'm happy to throw that out to the group. Yeah.
So I think that one of the keys to many of the conversations that are happening now about racial justice really hinge on the fact that you need a broader base of perspectives, right? And that's really what diversity brings to the table. But it's not just having those people at the table, it's including them in the conversation and giving that those people a voice, just like John was talking about his background and Akemi, actually all of us. It's one thing to have a different perspective. I know from my own experience, I definitely see things differently than some of my colleagues who grew up in different areas or have had a different background. But my opinion has not always been appreciated or listened to or reflected in ultimately the decisions that are being made and the policies that are being shaped about, let's say, criminal justice, for instance. So there's a speech that was offered by Abby Wambach, who is a U.S. women's soccer player, to Barnard College, and it was about gender, it was about women. And she likened the absence of women's voices to a story she heard about wolves being overhunted in Yellowstone National Park. And the absence of the wolves had caused all of these terrible things to happen in the park. You know, too many bears, too many deer, eating of certain berries, the killing of trees, all these things. When they reintroduced the wolves to the park, suddenly nature was in balance again because it put the bears in check, which allowed the growth and actually changed the direction of the water flowing in the park. And she says this is like women's voices. I would broaden that and say that is like the voices of women and people of color who have been excluded, either implicitly or explicitly, based on the fact that our legal system was created by white men for 200 years. Many of the doctrines that we rely upon were made at a time that there was no one else on the bench. So for instance, I remember when I learned about search and seizure, one of the things was this idea of consensual encounter, a temporary detention. And the question is did that person feel free to leave? That's the trigger. And I remember thinking that didn't count as a search because the person felt free to leave. And I was imagining my grandfather on his bike riding home from a farm with cash in his pocket, being stopped by a police officer, and would he feel free to leave? And the answer is absolutely not, never in a million years. But that's an example of a perspective that was not shared at the time that those doctrines were being created. And so to that extent, certain voices or views have been excluded and are not represented, and I think they need to. So many of the things that John is talking about with increasing diversity by getting a bigger candidate pool into law school, from law school into careers in public service, and from public service to the bench are increasingly important. And a lot of it actually does hinge on mentorship, I think, Dean Waterstone, because you don't just need, you need people actively bringing those in, because people from those backgrounds don't have the same path to the bench or to law school even than other people might. And I think that's really the starting place. You're muted.
If I could jump in, Michael, I just wanted to say that I was thinking about my time at Loyola. At the time I attended Loyola, there were no Black professors, not even a single one. In fact, I was president of BALSA at both Loyola Marymount University and Loyola Law School. And at that time, our faculty advisor was a contracts professor named John Garbisi, because there was no African-American person who could do that job. And it wasn't until years later that Lola McAlpin Grant joined, and she later became that person for the BALSA. But that tells me that at that time, there was not much of a thought about how law students would matriculate, function, and adjust to law school. And there was not really set in place a form of mentoring for the students. And I think it's important that they have that. I find myself doing that a lot for law students in schools where they don't have an African-American faculty rep or professor or anyone they feel that they can turn to. I started seeing law students from other schools coming to me for that type of mentorship just out of the blue. And I suspect it's because they don't feel represented in their schools, or nor do they feel that they have a place at the table at discussions about curriculum or what's going on with students and how they're adjusting, and what they can do to improve their grade point averages, and how they can graduate and get the jobs that they want and public facilities or the DA's office, public defender's office, so on and so forth. You know, there's a lot of rushing by law firms, and often those students are not approached by law firms if they're not in the top 10% of their classes. So there's definitely a need for more growth and more recruiting of African-American law professors, because I think it starts there. And it would have been amazing for me to have had that experience when I was at Loyola, but I just did not, if I'm being honest. There was no one who could fit that mode. I don't know how it was when John went. I would suspect it was about the same in terms of representation of African-American professors at Loyola Law School. I know we have Professor Williams now, but at least now we have Professor Williams and others who do mentor kids a lot and send a lot of kids to me. That's how they connect with me, through Professor Williams.
Great. Thank you, Judge Codrington and Judge Murillo before. Other input or thoughts on that question? Judge Arakaki?
I think that something that John said really resonated. And when we're talking about having a place at a table, having your voice heard, I think that we're not talking about just the judiciary, we're talking about just in general. One of the things John mentioned was his brother getting arrested for really no reason, right? And when we talk about really access to education, to higher education, to scholarships, anything, right? To become a lawyer, to pass the ethics, you know, the ethical background, the background check, all that stuff. We're talking about individuals who suffer getting arrested, getting harassed, false charges, all of those kinds of things that for some of, you know, luckily it worked out for John's brother because, you know, he was able to navigate that. But how many of our kids, I will say our kids, because I work in dependency and delinquency systems, have these things on their record that they will never be able to get off of their record because they don't have somebody in their family or somebody to help them navigate that. And then when they need to try to get financial aid, they get dinged, or when they have to go through this ethics background, or when they go to a job interview and have to talk about those arrests. And so I think it's really about opening up our minds to talk about how do we ensure access, making sure that our kids aren't getting, you know, having these things in their background or on these arrests staying on their record so that they feel that they can't apply for these things because they don't want people to ask. Ensuring that they have access to make sure that those records are expunged, making sure that kids who are in schools where they have zero tolerance for something, and, you know, another kid in a private school would just get detention for a day and our kids get expelled or suspended, right? It's access to education. It's all of those things that are all rolled up into these conversations we're having now. But sitting in the role that I sit in here in dependency, seeing the struggles of our families and our kids every day, thinking about how is this going to affect them later with regard to their access and their ability to sit at those tables really is what's I'm struggling with every day, to try to ensure that we're making sure our kids are being protected in that fashion so that later on they aren't having to deal with those types of additional obstacles in front of them.
Thank you.
Add to that, Judge
yeah.
Waterstone, I agree 100% with Akemi, and I think that's why I characterize my journey to the bench as stumbling, because it has to do with what has merit. A kid from a background like the one Akemi is describing, where you don't have lawyers in your family, you don't have this perfect straight trajectory. When I was on the Jenny Commission, I found this to happen, and I can't divulge what happens in those discussions, but there were the categories of candidates where some people on the committee would be asking questions like, what have they published? What fancy law firms have they worked for? Where others of us were looking at, wow, here's a candidate from a diverse background who has been serving hundreds and hundreds and hundreds of people who have these wonderful things to say, and somehow that wasn't valid, but having published this and worked at the right law firm was valid. And that example, it can be carried through all the way down to high school. I don't think you should have to have a straight beeline trajectory to your goal in order for it to have merit. I think, in fact, sometimes when you're stumbling, your experience is even greater because you have a multifaceted perspective about life and about people and about the public that you ultimately serve, and you can effectuate greater justice that way. And so it is imperative to bring and find it to be important to have all of those perspectives as these policies and as laws and as careers are being shaped. I just wanted to add that. I think it's important.
Thank you. for that. I'm really grateful for everyone's responses on this important question. I always try to bring both awareness and a measure of humility to these conversations. I'm not just the white male dean of Loyola Law School. I'm the 18th white male dean in a row. So hopefully that won't always be the case. Judge Arakaki, I'd like to pick up a thread that you were talking about that really various folks have touched on. So we find ourselves in the middle of a global pandemic. And one thing we know is that is making every vulnerability in society worse. And we're simultaneously having or re-engaging in these important conversations on racial justice. And we know the pandemic is impacting communities of color differently. And I just wonder if you could comment on what you are seeing from the bench on this and how that impacts these larger conversations about inclusion and justice in our profession and in our society that we're having.
Well, for me, I am going to be very honest in saying that the dependency court has really tried to ensure that access to justice remains imperative in our everyday life, which we know it is. But with regard to during the pandemic and being very careful with how we as a system are making every effort to ensure the safety of the children of Los Angeles County, the families of Los Angeles County, and ensuring access to the court during this very critical time. We are in constant communication with our justice partners to try to ensure that our families are receiving services to the extent that's possible during this time. I have to say we've been very grateful for their participation in that endeavor, but we've also been very fortunate to be able to have remote proceedings moving forward. Since the court reopened, we have really made efforts to meet the needs of our families by having remote proceedings and ensuring that we're trying to resolve matters, get children safely home when it's appropriate, but also ensuring that children who are not safe in a particular home or in a certain setting are being cared for and appropriately supervised. And so in that regard, we are doing everything we can to ensure that. But with regard to all of the other conversations, all of the other issues, I think it's very true. Michael, you said it very well. Like, every single aspect of everyone's life is being taxed right now. And the court is just doing everything we possibly can to ensure that we're open to serve our communities to the extent that we can in this setting.
Thank you, Judge Arakaki. Other observations or thoughts?
Dean, can I clarify the question? Because one of the prompts you had given us in the email had to do with COVID kind of exposing these vulnerabilities and how that affects racial justice. I wanted to clarify the question that you asked Judge Arakaki had more to do with technology. I think I missed a thread in the question, and so I wanted to clarify that with you.
Yeah, it's totally fair. No. And it was a big question. I guess I was more trying to get at the former as opposed to technology. This issue of we're in a pandemic, which is, revealing vulnerabilities. It is impacting communities of color differently. We are having these important conversations about racial justice and justice. And I was just looking for what pieces of that, if any, which are big questions, you were observing from your vantage point as a judge, and I guess just any other thoughts on that constellation of issues more broadly. So I can be more specific if it's helpful, but I was kind of putting it out there just as in what ways do you observe COVID impacting vulnerable communities in ways that are challenging from a justice perspective and inclusion perspective?
Michael, I was working when the pandemic hit. I had been coerced into taking an assignment starting the day after Christmas. And I finished that assignment up and tried to come back home, but I ended up in downtown LA. And I was there until March 16th when the court shut down. But one of the things that I've really been amazed at is how well the leadership of the LA Superior Court responded to this crisis, just as the leadership at the law school and at LMU did almost overnight. And there are things, I mean, I can remember 25 years ago being on committees that were trying to use technology to do distant arraignments and that sort of thing. And it never came to be. You know, there were court rules and all that sort of thing. And this pandemic has resulted in judicial leadership thinking outside of the box. And many of the things that they are doing now to ensure safety during these pandemic times, I think we're going to see from now on being used as a regular part of what the court does. I mean, there's no reason to have 4 lawyers sitting around for 3 hours waiting on the one lawyer who they need before they can call the case and have it go forward, when they can appear telephonically or on Zoom or something else. So we're going to see much more of that, which will make the courtroom environment a lot safer. But I think the biggest effect that the pandemic is having is on the right to a jury trial, because we were having problems getting jurors because of the one trial jury system before the pandemic. Now no one wants to be close to anyone, so you can't do that in a courtroom. We have courtrooms that you can't put people 6 feet apart in the jury box. You're going to have to spread them all over the courtroom, perhaps some even in the custody area. And I don't know how that's going to work, but it's going to certainly affect people's right to a speedy trial until there's a vaccine.
So, and I will try to clarify the question a little bit. It's interesting. I taught a summer course this summer on socio-legal impacts of COVID-19. Fascinating class. And amongst other guest speakers, we brought in Judge Brazil and talked with him just about the impossible range of decisions, you know, that he's been facing and confronting the court. But I guess, Judge Meigs, to use your response to maybe reframe the question a bit, you know, one of the things we talk a lot about in our curriculum is we are truly facing an access to justice crisis for so many segments of our society. And that was before the pandemic. And, you know, the pandemic is not going to make any of that better. Maybe there are some lasting things that we can be hopeful about in the way that Judge Meigs has highlighted. But I guess I would just welcome, to the extent anyone has any observations on that piece, that the impact that this is having on vulnerable communities.
I think one thing that I've observed is obviously Judge Brazil has been doing a great job as a leader, as Judge Meigs mentioned. I think I have worried personally, even though I'm not in the family courts. I'm glad Judge Arakaki's independency, but for a while, civil just had to be completely shut down, plus much of family law. So the ability to get restraining orders, things that are imperative for people's lives at a time when they're in an enclosed space. Same thing with domestic violence crime. People are sheltering in place. They have less access to the court. Some women are in dangerous situations depending on who they're living with. And so that has certainly been exacerbated by COVID-19. There's been issues with working people paying tickets, and the fact that even though we might be able to offer technology, you know, we were moving towards having greater technology, and then COVID-19 hit, and that exacerbated the situation because you kind of have to have technology now to be able to appear in the court. But not everybody has access to a laptop or a PC or even a really advanced iPhone where they can access all of those things. So that certainly has caused problems. I have found it interesting just because of the work that I've done on pretrial release, on how we were moving to this model of really questioning, do people need to be detained prior to trial to the extent that they are in exchange for a bail amount, and how safe is it to have bail? And suddenly COVID-19 hits and we get these emergency bail schedules where everybody's released because it's more dangerous to keep them in to keep them out. So it has really caused a lot of interesting dynamics and really pushed, I think, a lot of the issues that were brewing to the forefront. And I think that it's actually, in the end, probably a good thing, because it's forced us to come up to speed on our ideas about pretrial release, on technology, on and making the courts available to people, as Judge Arakaki so aptly stated, is happening in dependency.
Great, thank you.
I was going to say,
yes,
the Court of Appeal is sort of behind the times and behind a dark curtain in terms of technology, but COVID-19 has forced us to move to a model of oral argument via Zoom. We use a different program called Blue Jeans, but we had our first oral argument in last month through that technology, and it went well, but it was very different. And I echo the sentiments of Judge Murillo in that I don't know that people who don't have access to technology, to a laptop, or iPad, or an iPhone, would be able to participate in oral argument as they do in person oral argument, where we have plenty of pro pers. I've noticed a drop off in the pro pers appearing for oral argument and just waiving oral argument, as opposed to the number of pro pers that ordinarily would appear during any given oral argument month. So technology definitely has had an impact on oral argument.
Thank you. Well, this is a fascinating conversation. We could no doubt continue for hours, but I promise to be respectful of your time. So let me just conclude by, on behalf of your law school, thanking you for your important service to our profession and to our world, thanking you for the mentorship and guidance that you provide to our students and our recent alumni. What you do matters, and it's so important. So we're really appreciative for all that you do for Loyola. We're appreciative that you would help us do this to celebrate our 100th anniversary. As many of you know, I've used my vast powers as dean to declare that our centennial will extend into as much of 2021 as we need to really do it justice. So we're actually thinking we're gonna kind of consider September 8th, which was the very first day of classes, September 8th, 1920, as kind of a, we're going to keep the year rolling, restart it on September 8th and keep it going through next September 8th. So doing these on Zoom is great. We look forward to the day when we can all congregate together in person. But again, on behalf of Loyola, thank you for what you do for the institution and your service to the profession. So we really appreciate it. Thank you.